Welcome back to the Constitutional Clarion. This is a quick video about the High Court's judgment in the Yunupingu case, which was handed down by the High Court this morning, my time. The case deals with three issues relevant to the native title claim by the Gumatj clan of the Yolngu people in relation to the Gove Peninsula. The area has been subject to mining since a mineral lease was granted by the Commonwealth back in 1958. The three issues were as follows. 1. Whether the just terms requirement for any compulsory acquisition by the Commonwealth extends to acquisitions of property in the Northern Territory. 2. Whether the nature of the common law native title is such that it doesn't trigger the application of the just terms clause because it's inherently defeasible. And 3. Whether a pastoral lease granted by South Australia in 1903 before the land became part of the Northern Territory appropriated all the minerals in the land to the Crown. Now, I'm only going to deal with the first two questions because they are the constitutional ones. First, as always, a little background. Most of the Commonwealth Parliament's legislative powers are set out in Section 51 of the Constitution, such as its powers in relation to things like taxation and quarantine, copyright, defence, marriage, powers, corporations, all of those sorts of things. Now, amongst that list of powers is Section 51(31). Some of you may remember this power from the movie, The Castle. It was the reason why the lawyer, Dennis Denuto, memorably had to learn Roman numerals. As he said in that film, it's the Constitution, it's Mabo, it's justice, it's law, it's the vibe. Well, actually it's just Section 51(31), which says that the Commonwealth Parliament has power to make laws with respect to the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power to make laws. It places a condition on such an acquisition that it be on just terms, meaning fair compensation must be given. But what if the Commonwealth Parliament relied on a separate power in Section 51 to acquire property, such as its power to make laws with respect to lighthouses or trading corporations, or what if it were to acquire property for defence purposes? Would that guarantee of just terms compensation in Section 51(31) still apply? The High Court has long said, yes, it does. The guarantee of just terms compensation affects acquisitions of property that could otherwise have come under any other Section 51 power. Otherwise, the guarantee of just terms would be worthless. That guarantee, however, does not extend to the states compulsorily acquiring your property. They can do so without any constitutional obligation to pay just terms compensation, although obviously there are statutes in place in each state that do provide for such compensation. There was a referendum at the federal level in 1988 to extend the constitutional obligation to the states so that they would be obliged to pay just terms compensation. But the referendum failed, as tends to happen in Australia. This leaves the states free not to pay just terms compensation if they so choose. But what then about the territories? Section 122 of the Commonwealth Constitution gives the Commonwealth Parliament full power to make law for the government of any territory surrendered by any state to the Commonwealth. This includes the Northern Territory, which was surrendered by South Australia in 1911, and the Australian Capital Territory, which was surrendered by New South Wales in 1909. The Commonwealth Parliament has full power to legislate for these territories in the same way as a state parliament can legislate for a state. In this case, the Commonwealth Parliament's not confined to those particular subjects listed in Section 51 of the Constitution. Section 122 gives it plenary power to legislate about anything with respect to a territory. But because Section 122 is separate from Section 51 of the Commonwealth Constitution, and because it confers quite a different legislative power, which is more akin to one held by the states, should it be subject to the just terms guarantee in section 5131 when no such guarantee applies in the states. In the past, the governance of territories has been treated quite separately from the rest of the Constitution. And in a case called Teori Tau and the Commonwealth in 1969, it was held that the just terms guarantee did not apply in the territories. The logic and fairness of this decision has been criticised for a long time. In the Newcrest case in 1997, 3 judges agreed that the Teori Tau case should be overruled. But that wasn't enough for a majority. There are 7 judges on the High Court, and when you've got the entire court sitting, you need, of course, 4 judges for a majority. Later, in the Warragul case in 2009, 4 judges supported the overruling of Teori Tau, and they held that the just terms guarantee did apply in the territories. Now, this is enough for a majority, and you'd think that would be the end of the story, but of the 4 judges, 3 formed part of the majority in the determination of the case, and one of them was in dissent for a reason that was unrelated to the just terms point. When this point was raised in the Yunupingu case, in the proceedings below in the federal court, the judges decided that they were bound by the decision that the High Court made in relation to each separate question in the demurrer, which was the form of the legal proceeding in that case, in Warragul, rather than being bound only in relation to the overall result. On that basis, the finding of the 4 judges in Warragul on the question of overruling Teori Tau would be binding on the federal court. Interestingly, on appeal to the High Court in the Yunupingu case, it didn't take that approach. It found that Teori Tau had not yet been overruled because the findings of the 4 judges who did so in the Warragul case was not part of what lawyers call the ratio decidendi of the case, that is, the reasons for deciding the case. But the court in Yunupingu then went on to formally overrule Teori Tau. 4 of the judges said at paragraph 44, "The time has come for it to be finally and authoritatively declared that the power conferred on the Commonwealth Parliament by section 122 of the Constitution to make laws for the government of a territory does not extend to making a law with respect to an acquisition of property otherwise than on just terms within the meaning of section 5131 of the Constitution." One small odd thing about this decision, however, is that in giving reasons why the power to make laws for the territories ought to be subject to the just terms requirement in section 5131, 6 of the justices in Yunupingu pointed out that in the case of ICM Agriculture in 2009, a majority there had held that grants under section 96 of the Constitution are also subject to the just terms requirements in section 5131. But according to my recollection, ICM was actually one of those other annoying cases where 4 judges had reached that conclusion, but again, 3 of them, Chief Justice French, Justices Gummo and Crennan, were in the majority, and one of them, Justice Hayden, had dissented in the outcome of the case for different reasons. So it seems to fall into the same category as the Warragul case being an ineffective precedent. Unless I'm missing something, and maybe I am, but it does seem rather odd. The second issue in Yunupingu was whether the nature of native title was such that section 5131 doesn't apply to it anyway. The High Court has previously found that property, for the purposes of section 5131, can include certain rights that are held by a person, such as a vested right to sue for compensation. However, the court has also held that some types of rights, where they have no existence apart from statute, are inherently defeasible. What they mean is that the nature of the right is such that it can be granted and removed at will. Say, for example, you're entitled to receive social security payments, but then the law is changed so that the payment is reduced, or you lose your entitlement. You cannot claim that this is the compulsory acquisition of your property and that you must be given just terms compensation. When it comes to social security, it was always intended that Parliament would be able to adjust the law to reflect the needs and the available resources of the community at any time. What Parliament can give, Parliament can also take away. Examples of this include the case of Health Insurance Commission and Peveril from 1994, where a Medicare benefit payment to bulk billing doctors was reduced. Attorney General for the Northern Territory and Chaffey from 2007, where rights to a purely statutory scheme of workers' compensation were reduced, and Cunningham and the Commonwealth in 2016, where perks for retired Commonwealth politicians, such as a gold pass, were reduced or removed. In these cases, the reduction or removal of rights was not regarded as an acquisition of property by the Commonwealth for which just terms compensation had to be paid. They were rights which had been granted by statute and were inherently susceptible of variation, or inherently defeasible. Otherwise, every time Parliament conferred rights or entitlements on people, they could not ever be reduced without having to pay compensation for it. The odd thing about the Commonwealth's claim in the Yunupingu case was that it concerned rights recognised by the common law rather than statutory rights. These rights existed before British settlement of Australia and came to be recognised by the common law. So they did not fall within the original rationale for this category of vested rights to which Section 5131 does not apply. The High Court did not accept the Commonwealth's argument that native title rights were inherently defeasible. While the justices recognised that native title rights, as recognised by the common law, could be extinguished by valid statutes or exercises of executive power, they said this of itself does not make them inherently defeasible in the sense relevant to Section 5131. The joint judgment of 4 of the justices said at paragraph 80 that if the Commonwealth's arguments were accepted, it would undermine the motivating rationale of the decision in the Mabo No. 2 case of ensuring that all people, including native title holders, are equal before the law in the enjoyment of their human right to own and inherit property. They didn't want to destroy that equality and perpetuate a form of injustice. So what does all this mean in the end? Well, it means first that if the Commonwealth took action between 1911, when the Northern Territory was surrendered, and 1978, when self-government was granted, which had the effect of compulsorily acquiring native title rights, then just terms compensation would be payable. That could potentially amount to quite a significant sum, but will have to be assessed by courts in ongoing proceedings about different parcels of land, depending upon their history. For example, some rights may have been extinguished before the land ceased to be part of the state of South Australia. Now, these are complex issues which will have to be worked through before the full consequences of the decision will be known. I hope this video does give you an idea of what the case means beyond the probably more superficial descriptions in the news. The judgments in the Yunupingu case do run to 175 pages, so I can't do it complete justice in a short video, but I hope I've adequately conveyed the gist of it. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.